Your doctor said yes. Your insurance company said no. But here's what your insurance company will never tell you about that no. The person who said it was not a doctor. It was not a nurse. It was not a human being who read your file. It was a computer program, an algorithm, one that was built by UnitedHealthcare, deployed across millions of patient accounts, and that a federal court has now found was denying care at a rate that cannot be explained by anything other than a deliberate design choice. That algorithm is called NH-Predict. And according to the families who filed a class action lawsuit against UnitedHealthcare in federal court, 9 out of every 10 claims that algorithm denied were ultimately reversed when patients appealed. 9 out of 10. Not occasionally wrong, systematically wrong. And the company had the data to know it. Here is what just changed. On March 9th, 2026, a federal judge ordered UnitedHealthcare to produce every internal document related to NH-Predict. Its design specifications, its training data, its performance records, and internal company emails going all the way back to January 2017. The deadline to hand over those documents was April 29th, 12 days ago. What is in those documents is going to tell us whether UnitedHealthcare built an algorithm that was designed to override your doctor. And in a few minutes, I'm going to show you exactly what the Senate investigation and the court filings already prove before those documents are even released. But I also want to give you something else before this video is over. I am going to give you the exact 17 words that force your insurance company to take any denial out of the automated system and put it in front of a licensed physician, not an algorithm. A real doctor. Your insurance company is hoping you never say them. I am going to make sure you have them. Before I get into NH-Predict specifically, you need to understand the scale of what I am describing, because this is not a Medicare story. It is not a senior story. It is an everyone story. UnitedHealth Group covers more than 50 million Americans directly. When you include Aetna and Cigna, the 3 largest commercial insurers together cover more than 180 million people in this country. That is more than half of every person in the United States. And all 3 of them are using AI-powered tools to make prior authorization and claims decisions, not as a support layer that helps doctors, as the primary decision engine that tells your insurance company whether to approve or deny your care. A 2024 survey by the American Medical Association found that 61% of physicians, more than 6 in 10 practicing doctors in this country, believe that unregulated artificial intelligence increasing wrongful prior authorization denials, not helping patients get better care, increasing the rate at which patients are told no. Now you might be thinking, that sounds like a Medicare problem, a problem for older patients. That is exactly what insurance companies want you to think. Because while NH-Predict specifically targeted Medicare Advantage post-acute care claims, the logic behind it, the AI-driven prediction model that generates a coverage ceiling and overrides physician judgment, is identical to the tools Aetna, Cigna, and Blue Cross are using right now for prior authorization decisions on employer-sponsored plans and marketplace plans. The same financial incentive, the same gap between what your doctor says you need and what an algorithm says you can have. If you have health insurance of any kind through your employer, through the marketplace, or through Medicare, this is about you. Here's what the American Medical Association also found. 38% of physicians said they had a patient suffer a serious adverse medical event, that is the clinical term for hospitalization, permanent injury, or death, because a prior authorization or AI-driven denial delayed or prevented necessary care. 38%. More than 1 in 3 doctors working in this country today has watched a patient be seriously harmed because a machine said no before a human could say yes. I want you to hold that number in your mind as I show you exactly how this system was built. UnitedHealth Group is not just an insurance company, it is a conglomerate, and that structure matters enormously for what I am about to show you. UnitedHealth Group owns Optum Health. Optum Health acquired a company called Navihealth, and Navihealth built NH-Predict. That chain of ownership means that when UnitedHealthcare was using NH-Predict to decide whether to cover your post-surgical rehabilitation, the tool making that decision belonged to the same parent company collecting your premiums. The insurer and the algorithm vendor were the same entity. There was no independent check. Here is how NH-Predict actually works. When a patient is discharged from a hospital after a knee replacement, a hip fracture, a stroke, and their doctor recommends a period of inpatient rehabilitation at a skilled nursing facility, the insurance company has to decide how many days of that rehabilitation to cover. Prior to NH-Predict, that decision involved a clinical review of the patient's specific file. After NH-Predict was deployed, the decision was made by an algorithm. NH-Predict analyzes hundreds of variables: your age, your primary diagnosis code, your secondary diagnoses, your prior hospitalizations, your cognitive and mobility scores from the hospital intake assessment, your geographic region, your historical utilization of post-acute services. The algorithm processes all of those variables and outputs a predicted length of stay, a number of days it believes is sufficient for someone with your profile to recover. That number becomes the approval ceiling. Your insurer approves coverage up to that ceiling. Any stay your doctor recommends beyond it is denied. Not reviewed, not discussed, denied. Your doctor's recommendation is one input among hundreds. The algorithm's output is the decision. Now here is where this gets considerably worse. And this is the number from the Senate investigation that I want you to hold on to. The Senate Permanent Subcommittee on Investigations published a full report in October 2024 examining UnitedHealthcare's use of NH-Predict. What they found was this. In 2019, before NH-Predict was widely deployed, UnitedHealthcare's denial rate for skilled nursing facility stays in Medicare Advantage was 1.4%. By 2022, 3 years into the algorithm's deployment, that denial rate had risen to 12.6%. That is a 9-fold increase. 9 times more denials. Same patient population, same medical procedures, same recovery needs. The only thing that changed was the algorithm. And the Senate investigation found something else. The patients who were denied extended stays under NH-Predict and who were discharged early were rehospitalized at measurably higher rates than patients who received the full stay their doctor recommended. The algorithm did not just make wrong coverage decisions. Its wrong decisions made people sicker. They ended up back in the hospital, which cost the healthcare system more than the rehabilitation stay would have cost to begin with. But here's the number that should stay with you when you think about how UnitedHealthcare responded to all of this. Among the patients who actually appealed their NH-Predict denials, 80.7% won. More than 8 in 10 patients who fought back had their denials overturned. Their doctor was right. The algorithm was wrong. 8 out of 10 times. But here's the other number. Fewer than 1% of patients who receive a denial actually file an appeal. That gap between how often the algorithm was wrong and how rarely anyone challenged it is not a side effect of the system. I am going to show you why it is the system. Linda Hargrove is 63 years old. She is a retired middle school art teacher from Grand Rapids, Michigan. She has had a Medicare Advantage plan through UnitedHealthcare for 7 years. In those 7 years, she has never missed a premium payment. She has never filed a claim that was not legitimate. She trusted her plan. Last November, Linda had a total knee replacement. Her orthopedic surgeon, who has performed more than 2,000 of these procedures, recommended 14 days of inpatient rehabilitation at a skilled nursing facility before Linda could safely return home. This was not an aggressive recommendation. It was standard for a patient of Linda's age, her bone density profile, and her single-occupancy home situation. Her surgeon filed the request with UnitedHealthcare. NH-Predict approved 5 days. Her surgeon filed a clinical appeal the same afternoon. He submitted his full operative notes, his post-surgical assessment, a physical therapy evaluation, and a 2-page letter explaining that Linda lived alone, had no ground floor bathroom, and that discharging her at day 5 posed a documented fall risk and a statistically elevated readmission risk. He had seen patients like Linda refracture. He was specific about why 14 days was medically necessary. UnitedHealthcare denied the appeal. The denial letter arrived in 4 sentences. The last one said the same 4 words that millions of Americans have now memorized through their own experience. Not medically necessary. Linda went home after 5 days. On day 9, she fell in her bathroom. She was readmitted to the hospital with a fractured right wrist and a significant setback in her knee recovery that her surgeon told her cost her 6 to 8 additional weeks of healing. The readmission, the hospitalization that the denial was supposed to prevent expenditure on cost UnitedHealthcare more than the full 14-day rehabilitation stay would have. Linda did not know at the time of her original denial and at the time of her appeal that she had the federal right to request an independent external review. She did not know that a third party with no financial relationship to UnitedHealthcare could have legally evaluated her surgeon's recommendation and overruled NH-Predict's decision. She did not know, because nobody at UnitedHealthcare told her. And the reason nobody told her is the part of this story I need you to understand clearly. Linda's case is not a rare failure of a system that mostly works. The Senate investigation examined multiple cases like Linda's. Their pattern was consistent. Algorithm generates a shorter than recommended stay. Patient or physician appeals. Insurer denies the appeal citing the same algorithm's output. Patient is discharged. Adverse outcome follows. And in the class action lawsuit now moving through federal court, the plaintiff families are arguing something that goes beyond algorithm error. They are arguing that UnitedHealthcare had Linda's outcome data. They had hundreds of cases like Linda's. They could see exactly what happened to patients who were discharged on the algorithm's timeline rather than the physician's timeline. And they chose not to change the algorithm because the algorithm, even when it was wrong, was profitable. Let me put the financial side of this in plain numbers. UnitedHealth Group reported $22 billion in net earnings last year. That is profit after paying claims. after overhead, after every expense the company reports. $22 billion. Every denied claim that goes unappealed is direct earnings. The premium was collected. The care was not paid for. The money stays with the company. Here is how the math works on NH Predict specifically. The algorithm denies a claim. The patient does not appeal statistically. 99 out of 100 do not. The insurer keeps the money, but if that one patient who does appeal wins 80% of the time, which is what the data shows, then for every 100 denials, 80 people had a legitimate claim, wrongly denied, and simply never got paid. That is not a side effect of using AI for efficiency. That is the output the algorithm was generating at scale with the company's full awareness, and this is why the court order from March 9th is significant in a way that goes beyond this one lawsuit. The plaintiffs are not arguing that NH Predict was a bad tool that made honest mistakes. They are arguing that UnitedHealth Group knew the tool was generating a denial rate that no legitimate clinical review process could produce, that they had the appeal reversal data, that they watched 8 in 10 appeals succeed, meaning 8 in 10 denials were clinical errors and chose not to adjust the algorithm's parameters. Because adjusting those parameters would have reduced denials, and reducing denials would have reduced earnings. That is what the court has decided deserves a full answer. The judge ordered discovery across 6 of 7 document categories the plaintiffs requested. She granted or partially granted nearly every request. She ordered UnitedHealth to produce records, specifically addressing, and I am using language from the court's own order here, whether the technology was designed to override the clinical judgment of treating physicians. That is the question on the table. Not whether the algorithm made mistakes, whether it was designed to make them. Stay with me, because what the documented record already shows before the April 29th document production is damning enough on its own. The Senate Permanent Subcommittee on Investigations spent months examining UnitedHealthcare's internal records before publishing their report. They did not have to go to court to get them. They used congressional subpoena authority. And what they found went beyond the denial rate numbers I already gave you. The subcommittee found that Navihealth's NH Predict had a documented pattern of generating predicted stay lengths that were significantly shorter than the stay lengths UnitedHealthcare's own contracted physicians. The doctors on the company's payroll were recommending in peer-to-peer review calls. In other words, even the doctors who worked for UnitedHealthcare, when they actually looked at the individual patient files, were recommending longer stays than the algorithm approved. The algorithm was overriding not just the treating physician, it was overriding the insurer's own medical staff. The subcommittee also found that Navihealth's executives were aware of the gap between algorithmic recommendations and physician recommendations as early as 2019. There are internal communications in the Senate record showing Navihealth staff discussing the discrepancy. There is no evidence in the public record that UnitedHealthcare acted to close that gap. The American Medical Association published its own findings separately. In a survey of practicing physicians in early 2026, 61% reported that AI tools are increasing inappropriate prior authorization denials. 38% reported having a patient experience a serious adverse event as a direct result of a prior authorization or AI-driven coverage denial. And the class action case itself, a state of Gene Locken and others versus UnitedHealth Group, is built on exactly the kind of documentation I described in Linda's case. Real patients, specific denials, specific readmission records, specific outcomes. The court has reviewed enough of that documentation to conclude that the case merits full discovery. That conclusion itself is significant. A federal judge, having reviewed the claims and the initial evidence, decided this case deserves the full exposure of UnitedHealth's internal records. The documents are in. The question is what they say. Here is the clearest statement of what happened before we get to what you can do about it. A company built a tool that predicted the minimum amount of care it could approve. The tool generated denials at a rate 9 times higher than the company's own historical baseline. More than 8 in 10 of those denials were overturned when patients fought back. Fewer than 1 in 100 patients fought back. A Senate investigation documented the pattern. Families sued. A federal court ordered the company to show its work, and the tool is still running. So what does this mean for you? It means that the next time your insurance company denies a claim, and statistically, if you have health insurance, you will receive a denial at some point. You have a federal legal framework that overrides the algorithm entirely, and I want to walk you through it step by step. These rights apply to you whether you have Medicare Advantage, an employer-sponsored plan, or a marketplace plan. They come from the Affordable Care Act and from the Employee Retirement Income Security Act, which governs most employer plans. They are not courtesy policies. They are statutory rights. Step 1, the internal appeal. When you receive a denial, you have 180 days to file an internal appeal. That is 6 months. Do not miss this window. File in writing, not by phone. Every internal appeal should be submitted in writing because that creates a documented record. Your appeal should include 3 things. First, a written statement from your treating physician explaining why the care is medically necessary. The phrase medically necessary needs to appear in that letter because that is the legal standard your insurer is required to evaluate against. Second, your physician's full clinical notes related to the recommended treatment. Third, any relevant imaging, lab results, or diagnostic documentation that supports the recommendation. The insurance company must respond within 60 days for standard appeals, 30 days for prior authorization requests, and 72 hours for urgent or emergency care situations where delay poses a health risk. If your situation is urgent, if delaying the care creates a meaningful risk to your health, request an expedited appeal immediately. Use those words. I am requesting an expedited appeal. The 72-hour clock starts from the moment you make that request. Step 2. The external independent review. If your internal appeal is denied, you have the right to request an external independent review. This review is conducted by a third-party organization that has no financial relationship with your insurance company. Your insurer is legally required to comply with the outcome of that review. They cannot override it. They cannot ignore it. And the cost to you is zero. This is the most powerful protection most Americans do not know they have. The algorithm made the decision. The internal appeals team, which works for the same company as the algorithm, reviewed it. But an independent external reviewer has no financial stake in the outcome. Their job is to evaluate the clinical evidence. And when they do, insurers lose more than 80% of the time. Step 3. The phrase. I told you at the beginning of this video that I was going to give you 17 words that change the conversation. Here they are. When you call your insurance company after a denial, you say this exactly. I am requesting an expedited, independent, external review under my federal consumer protections. Write that down. Those 17 words. Here is why they work. Insurance companies route most denial calls through a standard appeals queue. That queue processes claims according to normal timelines. But when you invoke your external review rights, specifically when you use the language of federal statute, you are no longer in the standard queue. You are invoking a legally separate process that requires escalation to a licensed physician reviewer outside the company. The representative on the phone may tell you they will pass along the request. Do not hang up until you have a case number and a confirmation that your external review request has been logged. If they cannot provide that, ask for a supervisor. You are not asking for a favor. You are invoking a federal right. The insurer is required to honor it. One more thing on this. If you are in the middle of a coverage dispute right now, if you have received a denial and have not yet acted, do this today. Go to the website for your state's Department of Insurance. Every state has one. Look for the external review request form. In most states, you can initiate an external review directly through the state, which bypasses the insurer's own administrative process entirely. File it yourself. Attach your doctor's supporting documentation. The state body forwards it to an independent reviewer. You do not need a lawyer. You do not need a patient advocate. You need the documentation your doctor can provide and the knowledge of the process that your insurance company was hoping you would never have. Document everything. Every denial letter, save it. Every appeal you file, keep a copy with a date stamp. Every phone call, write down the date, the name of the representative, and a summary of what was said. If your case ever reaches an external reviewer, a regulator, or a court, this documentation is your evidence. The families in the UnitedHealthcare class action built their cases this way. They saved everything. Now, a federal judge is using that documentation to demand that one of the largest companies in America explain its algorithm in open court. Your documentation carries the same weight. Start keeping it. If this is the kind of information you want to have, the federal laws, the specific processes, the exact language that your insurance company is counting on you, never learning, that is what this channel covers. Insurance companies have legal teams, lobbying arms, and entire departments dedicated to finding reasons not to pay you. The information that protects you from that system exists. It is documented in federal law. It is in Senate reports. It is in court records. Most people never see it because nobody puts it in front of them. That is what I do. Subscribe. There are dozens of laws and protections just like the ones I showed you today. Federal rights you have already paid for that your insurance company has no incentive to tell you about. That is what this channel covers. I want to leave you with the clearest version of what this story actually is. UnitedHealthcare built a tool to predict the minimum amount of care it could approve. That tool denied claims 9 times more frequently after it was deployed than before. More than 8 in 10 of those denials were overturned when patients challenged them. Fewer than 1 in 100 patients challenged them. A Senate investigation documented exactly what happened to the patients who did not. A federal court has now ordered the company to show whether the tool was designed to work that way. The algorithm is still running, but you now know the process that overrides it. You know the timeline, you know the documentation, and you have the 17 words that take your case out of the automated system and put it in front of a doctor who is not on the insurance company's payroll. UnitedHealthcare built a machine to predict how little care it had to give you. Most people who receive a denial never find out they had the right to fight it. Now you know you do.